It means a digital asset that is intrinsically linked to a blockchain system. So among the questions that came up, like, is a meme coin intrinsically linked? Well, maybe it is, maybe it's not, the value of which is derived from or reasonably expected to be derived from the use in a blockchain system. Again,
Okay,
you
no,
can hear all these, right? So, and then
so
for purposes of, it keeps going. For purposes of this subparagraph, a digital asset is intrinsically linked to a blockchain system if the digital asset is directly related to the functionality or operation of the blockchain system or the activities or services for which the blockchain system is created or utilized, including where the digital asset is one, issued or generated by the form of programmatic functioning, used to transfer value, used to access the activities. It's got a long, complicated definition. And look, they do a great job. I'm not criticizing the effort. I'm saying that inevitably, once you go down that prescriptive route, you have to answer each and every one of these questions.
we are thrilled to have Lewis Cohen as our guest today. So if you don't know Lewis, you should, but I will give him a bit of an introduction anyway. So Lewis is, I want to say, a crypto lawyer, but actually I'm going to say the crypto lawyer because he is the crypto lawyer. He works at Cahill NXT, but those of you who know crypto probably know him better as NY Crypto Lawyer on Twitter. And so, you already know that, he's the guy you want to talk to about what's going on the legal side of crypto if you want to understand it. And so that's why we have him here today. Obviously, under the new administration, we've had a lot of stuff happening on crypto. Today, we're going to try to focus on kind of the most recent stuff. So in particular, Congress is currently deliberating another crypto bill, meaning not the stablecoin legislation which passed, but another bill, which is sometimes sort of framed as the market structure bill. And of course, there are versions in the Senate and the House, and they have their own names. And I'm sure most people are having trouble keeping track of it. And this is exactly why we have Lewis here to keep everything straight for us. But before we really get into the details, I want to start off with like a high level thing here because Lewis, you got to remember, we non-lawyers, we do not have the sort of ability to sort of dig so deep in to begin with. So if you could give us at a high level, what is the scope of this market structure legislation? Like, what does that even mean? What is Congress trying to clarify through this legislation?
Yeah, Fahad and Brad, thank you so much for the very, very kind words, for having me on your awesome show. And I hope everybody is following the show. It's fantastic. Also, just to say, my remarks today are solely my own, not those of my firm or any of our clients. Delighted to be here and to talk to all of you. I think it's worth maybe just stepping a small step backwards and asking what I think is one of the most important questions if you're in crypto to ask, and that's WTF. What's going on here, right? What the heck? What is happening here? There are things of great interest to economists, to sociologists, financial engineers, to cypherpunks, to so many different things. What's happening and why are we talking about federal legislation in this space, right? What's going on? And we all know the broad story of the development from Bitcoin, full Turing complete projects like Ethereum and Solana, et cetera. But we didn't really need market structure, nor did we talk about it. People just kind of created assets, traded them with their friends, created decentralized marketplaces through smart contracts, and eventually we saw businesses come in and create more formal marketplaces. Throughout all of this, there's no legal structure really to speak of, but for, in the United States at least, the idea that people who send value from one place to another are regulated at the state level. If you've ever visited in the East Coast, we have David's check cashing, but they're money transmitters. And the only regulation we really have in the United States, but for the Genius Act that you mentioned, Fahad, regarding stablecoins, is still state money transmission law. And as crypto grew and grew, it seemed more and more ridiculous that this huge multi-trillion-dollar industry was regulated in the same way. And no disrespect to Davis check cashing, but it's really two very different things. And so the question then became, well, how do we do that? Who takes responsibility? And the ephemeral nature and the unusual nature of crypto assets immediately raised issues because here in the US, we have different kinds of markets. In most other jurisdictions, all financial markets are grouped under one regulatory framework. For example, in Europe, they're grouped under a law called the Markets in Financial Instruments Directive, or MiFID. Here, In the US, we have a securities regulator, as most of your listeners will know, and a commodities regulator. So, okay, state money transmission regulation doesn't really make sense. We need something better, but who, where, how? And that immediately brought to bear one of the most difficult questions that Congress has really struggled with. Well, how do we know when activity is securities activity and when activities is not securities activity? And so more than anything else, market structure regulation is seeking to help people understand which of those two broad categories their activity falls into. And then once you do that, how do those activities apply? How do those regulatory schemes apply to you? The securities regulatory scheme, or, in most cases, the commodities regulatory scheme. It's worth bearing in mind, I said deliberately, securities are not securities rather than securities or commodities, because some digital assets are not securities and they're not commodities. They're yet something else. NFTs are a good example of that. They're digital assets. They're unique. They share many characteristics, but generally speaking, they're neither securities nor commodities. So it's a complex area. Congress finally is now weighing in on this. And as you mentioned, Fahad, and I'll take a breath in a moment, but we have two broad approaches. The one that the House of Representatives passed in, I think that was either late June or early July, and then I think it was early July, and then another version that the Senate Banking Committee is proposing, which a discussion draft, which is not formal bill, it's not even risen to that level, and that was introduced about 2 weeks ago and published, I should say, really. And then we expect an actual formal bill to be introduced by Senate Banking when we come back from the August holiday.
Lewis, I want to interject and ask a question to just understand how we went from a state transmission law to asking the question, is it a commodity or is it a security? Like, what happened as you transition from state to the whole US that changed the question from, is this a transmission of value, to how should we categorize it? What in the law, or what caused this question to sort of change?
That's a great question to ask, because it's worth reminding ourselves, and especially for your listeners who are more on the scholarly economist side, what exactly is, whether it's a Bitcoin, Ether, or any which other thing, what is it? And it's really just a number. It's a number that is tracked on a ledger maintained by computers that you control with a password, which we call a private key. It's nothing more than a number. It's just that a network of computers will react if you give it an instruction about what to do with that number. So it's hard to say, is a number a commodity? Is a number a security? We know that the number allows you to move value. And so to your question, Brad, the natural starting point for the law to intersect with this issue is, if I own a Bitcoin and I send a transaction to Fahad's wallet address, public address that he gives me, I've clearly moved value to Fahad. And so clearly, if I'm doing that as a business on a regular basis, I'm probably triggering state money transmission laws if I'm doing it again as a business. But am I also doing securities activity, or am I doing commodities activity? That's less clear. The base level is I'm moving value. Where, however, if, for example, Fahad said to me, hey, I've created this new token. It's amazing. Everybody's going to use it. It's going to be the most cool thing in the world, but I need some money. Lewis, you seem to be a Mr. Moneybags over there. Why don't you give me some money? I'll develop this. I'll allocate you some of the tokens, and we'll all make a mint. What Fahad has pitched me is an investment scheme, and that is securities transaction. So where those lines arise is what's caused people to step from simply just state law, movement of value, let's regulate that, let's keep track of A is moving value to B, do we have records of that? Are they using it for illicit purposes? To a more sophisticated question, is somebody raising money? Do they need to be regulated as a fundraising activity?
Got it.
So, if I understand correctly, part of what is at play here is a bit of a path dependence. And what I mean by that is that the United States created this thing called the Securities and Exchange Commission at the federal level in the first half of the 1900s. And at some point, they created this thing called the CFTC. And so ultimately, those are institutions that are tasked with regulation with a particular scope. For instance, the SEC, as its name suggests, is supposed to regulate securities. And when we do value transfers, one way to do a value transfer is I could sell you a security, right? And forget about crypto. I could sell you a stock, right? And so I guess that has something to do with the SEC. And so there's a bit of a question to begin with about kind of like, when is the SEC relevant to something that I am doing in crypto, which I guess turns on, is this a securities transaction? So first of all, is that a fair framing? Or at least, maybe you can...
It's a perfect framing, Fahad, and perhaps because we've had many lunches and dinners together, it's worth bearing in mind, which you quite clearly allude to, a securities transaction is just a special case of a commercial transaction. So we can enter into all kinds of private transactions where I have some sneakers, I'm going to sell them to you. That's not a securities transaction. At a point, there is something that looks and feels more like an investment. And as a policy matter, our federal government passed a law, the Securities Act of 1933, that said, well, when something looks and feels more like an investment and less like a standard commercial transaction, we're going to regulate it differently. Different protections are needed, different disclosures are needed, and it's not just buyer beware. And so, yes, it's just a continuation with an unclear line as to where you say, okay, regular commercial transaction on this side, securities transaction, investment transaction, that side. Not always very clear at all.
Right. I think we eventually want to get into the specific versions of the bill, both in the House and in the Senate. But before we do that, I just want to clarify, because one thing that, people in the crypto community who are non-lawyers might have sort of heard, but don't fully, understand how it relates to the legislation you're talking about, or at all, is that the SEC has been making a number of statements about, to the effect of essentially, this is not, something in particular is not a securities transaction, or at least typically is not, or something like that. And so I guess one question is like, what is the role of the SEC in terms of saying whether something is a securities transaction versus Congress?
Yeah, again, these are all awesome questions. The law, quickly enough, in this area changed rather dramatically, I guess, last year. When the Supreme Court struck down a position that it had held for many years, which was that regulatory agencies were given tremendous deference in making interpretations of statutes to the extent it was within a very broad set of parameters that was known as the Chevron doctrine of a case involving Chevron, the oil company. And a later case called Loper Bright, the Supreme Court questioned that and said, no, that's that level of deference is not really constitutional. And in fact, now the SEC does have a role in saying we believe these types of transactions, should be considered securities transactions, but ultimately the final arbiter of whether particular activity falls within or outside of the ambit of our securities laws are the courts. The courts make the final decision, kind of like an umpire calls safe or out at the end of the day. And if you're not sure, you go to the replay desk, at least if you're playing baseball, and it's like that. And the courts are kind of that ultimate and final arbiter of whether something is inside or outside of our securities laws.
Okay, so maybe let's pivot then into the specific legislation. So you mentioned the House version, which I believe is called the Clarity Act, has actually passed the House. That doesn't mean that they won't have to reconsider something like it based on what the Senate does. But could you tell us basically what was in the legislation that passed the House?
Sure. So it's important to understand that in Congress, to move legislation forward, there are different committees of Congress. So in particular, in the House of Representatives, we have the House Financial Services Committee, and its jurisdiction includes, among other things that relate to securities and the Securities Exchange Commission. Their jurisdiction does not extend to matters that relate to commodities derivatives. People sometimes say commodities. It's important to bear in mind commodities directly, at least until now, are generally not, or transactions in commodities are generally not regulated at the federal level. Derivatives transactions, futures, options, swaps, etc., are what are regulated. That is covered by a completely different committee, the Agricultural Committee, and that's historical. Obviously, at one point in time, most commodities derivatives transactions were agriculturally based. Two different committees. In the House, those two committees, the Financial Services Committee and the Agricultural Committee, work together very cooperatively and very tightly to produce the Clarity Act, which includes elements that cover both the securities laws and the commodities laws. So the Clarity Act is a very all-encompassing bill. It's a bill because it's not yet become law. And it addresses in an integrated way, and this is much to be commended, both the securities law issues and the commodities derivatives law issues. One thing it does, which is quite novel, is it grants authority to regulate spot markets, that is to say, immediate exchanges of digital assets, or as they call them, digital commodities there, to the CFTC, which is interesting because that's for the almost with some very, very rare exceptions, the CFTC does not regulate spot or present markets, and they have different economic considerations that you could probably explain better than I could. So what the Clarity Act does is it brings together, and we can talk in a moment in a little more detail on what it does, but the key thing for listeners to understand is it covers both securities law issues and commodities derivatives law issues and creates a whole new category of regulation over spot transactions and participants in spot transactions, digital commodities exchanges, digital commodities broker-dealers, digital commodity custodians, etc. And all of that is, broadly speaking, under the oversight of the CFTC.
Right. So, actually you touched on a really important point there that I think particularly for people like myself who are not lawyers is very clarifying. And I want to first clarify whether I actually understood it correctly. Which is that, I think there's sort of let's call it a reductionist way of looking at this, which is Congress is going to tell us whether this is a security or a commodity. Now, incidentally, you earlier already mentioned that it could be neither of these things. But more than that, one thing that you touched upon when you were talking about the spot transactions is that in principle, Congress could also just expand the authority of an existing agency, right? Like just because, the CFTC in its title alludes to commodity derivatives, commodities futures, doesn't mean that they couldn't be regulating a spot market. And Congress could, in theory, sort of expand the jurisdiction. And so related to that, I kind of want to ask, how important is it for legislation to necessarily per se classify the assets in one category or another or neither versus just kind of like, I suppose, establishing a regulator for a particular set of transactions? And I guess from the perspective of the legislation itself, what is the focus there? Like, is there a specific attempt to try to classify these things, or is it more like, no, look, we ultimately need to just sort of identify a regulator for the activities?
You're right. There's a very practical element here, Fahad. Once a foundational decision was made that allowing spot activity in crypto assets to be regulated disparately at each state on a state-by-state basis as money transmission activity, once it was decided that's just not a good way forward, then you have to move up to the federal level. And you broadly have a couple of choices, as you say. You could give all the authority to one existing regulator. You could split it between two existing regulators, or more possibly, but at least two. Or you could create a third new regulator or regulatory body, or maybe self-regulatory organization. All of these permutations were considered, and in the House, they ultimately concluded that the best way forward, at least worst perhaps, was to give portions of oversight to the Securities and Exchange Commission and other portions of the oversight to the CFTC. But it's a very practical question, as you said. If it's not going to be at the state level, it's going to be at the federal level, and then you've got a finite number of choices: one, the other, both, or something new.
But there's Fahad asked this question that I don't think I got the answer to from you. It's like, how is that split decided? Is it that someone will declare this to be a security and this to be a commodity? Or is it that these agencies get to decide on their own?
Well, the goal with both the House bill and the Senate bill is to provide clear enough rules to allow everybody, both market participants as well as regulators and courts, to all make a determination. Here's what Congress intends to be on this side of the line or that side of the line. But Brad, as you suggest, at the end of the day, somebody's kind of got to decide. So the hope is, and one of the reasons the House named their bill the Clarity Act, is to make it as easy as possible to make that determination. Now, I would assert, as well intended as the House bill was, it's not at all that easy to figure this all out, nevertheless, because it's a very nuanced bill. It'd be very good for me as a lawyer because you'd spend a long time trying to sort that thing out. But it was very, very well intended, and it just simply demonstrates how challenging these questions are. The Senate approach, on the other hand, is much more simple, straightforward, not technology-based, but people have said, well, but there's too many loose corners, and there could be people that would use that to circumvent. And, fair enough. I think those are policy questions, right? Do we want a hyper-prescriptive set of rules that are very difficult to apply in almost every case? or do we want a principle set where we're going to have to deal with some edge cases at some point in time? And that's ultimately a policy question. That's why we have elected representatives ultimately to make those decisions.
So let's not bury the lead. Where did the House draw the lines and why?
So the House previously, and many of your listeners may be aware of this, had created somewhat similar legislation by a different name under the prior Congress, and that was called the FIT 21 Act. The FIT 21 Act adopted a slightly different view. It came up with an idea of restricted digital assets, and that was sort of an attempt to get at the fact that some digital assets behave similarly to securities. Ultimately, it became clear that that was not an optimal outcome. And in any event, the whole Congress rolled over into the 119th Congress, and we now have a different approach. Starting again with the Clarity Act, the House took a different approach. They clarified that as long as a digital commodity is sold pursuant to what is known as an investment contract transaction and does not contain certain limited characteristics, it should not itself be a security. Where it gets a little nuanced is certain digital commodities, when sold by in a fundraising transaction, are subject to significant restrictions, even though they're no longer called restricted digital assets or restricted commodities. And they sort of kick the can a little as to where the difficult question is. So most digital assets would not be securities, but some of them may be subject to transfer restrictions that could be quite onerous and make them feel much more as if they were securities. And so that really just stepped forward the difficult question, if you will.
Sorry, what do you mean by digital asset here? Because before you started off saying like Bitcoin is a number and you're representing like a change in this number, but to me, my bank account, Bank of America, is the same thing. And you're talking about digital assets and what they represent, but like what about digital assets is so different with like what makes the problem so different here than like sort of like traditional digital assets?
Well, yes, and thank you for calling it out, because one of our real issues is nomenclature, right? We don't absolutely have a standardized nomenclature yet. Some people still use the term digital asset. It was used, and I sort of started using that term because I was referring to the FIT 21 bill. Under the Clarity Act, we've sort of transitioned to digital commodities. Some people refer to crypto assets. It's a little bit of a mishmash. I think the hope is that most people know a digital asset when they see one, an asset that's tracked on a ledger. But to answer your specific question, Brad, what's different between, for example, a Bitcoin, which is, again, a number maintained by the various nodes that maintain the Bitcoin network, and $100,000 or whatever you've got in your bank account, hopefully. What's the difference between the two? Actually, although a number represents your bank account or anyone's bank account, that's not really what you own. You own something different. You own a claim against a bank when you have a deposit at a bank. Let's say you bank at the Chase Manhattan Bank. Your number, you may see $100,000 there, but really what you have is a deposit relationship, is contractual in nature, in which the bank says, I promise to give you, if it's a sort of checking type account, on demand, up to the amount of your money that we have credit for you. With Bitcoin, there is nobody that you're entering into any sort of legal relationship with. They're just like there's a number on a computer. So it's important to understand at that distinction, whereas everything else, there is some legal relationship that creates the value in question.
Okay, yeah, that makes sense. Yeah.
So I'm still, I guess, struggling a little bit to fully understand, or maybe even partially understand, where the House drew the lines. I mean, you mentioned earlier that they took a prescriptive approach.
Yes.
And you also mentioned something about sort of spot transactions being regulated by the CFTC, which is at a minimum highly suggestive of those spot transactions not being securities transactions, because presumably it would then be regulated by the SEC. But and I think also in your response about Bitcoin was suggestive that it wouldn't be classified as a security under Clarity. So maybe could you provide like a bit of maybe concrete examples of what Clarity might consider a security?
Sure. So let me I opened it up, which is always convenient when you're a lawyer. Is tell my associates work with me. Good to look at the law. So the core provision there is that they clarify that something that is an investment contract asset is not a security. An investment contract asset is a digital commodity. We'll come back to that in a moment. That can be exclusively possessed and transferred person to person without necessary reliance on an intermediary, as recorded on a blockchain, and is sold or otherwise transferred or intended to be sold or otherwise transferred pursuant to an investment contract or securities transaction. So as I said, it's basically a digital commodity. The catch here is that the definition of digital commodity in the Clarity Act is a much more sort of technology specific term. And there it has sort of a series of embedded definitions within the idea of digital commodity. And so figuring out whether a given asset is or is not a digital commodity is itself a little adventure. So once you know that you've got a digital commodity, and for example, Bitcoin is unequivocally a digital commodity, it would easily fall into that. But other assets, it's not particularly clear. It has to be, I'm just looking for my copy of the definition here, but it has to be something that is tracked on a blockchain or a blockchain system. And then you have to know that you're dealing with a blockchain, and some things. Layer 2, for example, raised some issues. Is a layer 2 a blockchain? Well, it's not really a blockchain, is it? So they've endeavored to address these things, but it's got many sort of embedded definitions that you have to figure out to know that you've got a digital commodity, to know that you've got an investment contract asset, to know that you don't have a security.
Right. Okay. Hold on. So there's a lot there.
Yeah.
And just picking at a few things. In what you read directly, there was the word blockchain, right? And then you also mentioned that layer 2s would not be considered blockchains.
Well, so initially, as the definition of digital commodity was drafted, it had a definition of blockchain, and the definition of blockchain appeared not to include a layer 2 solution, which is not really a blockchain. However, they sort of made some amendments that, hopefully clarified that, but, it's
Wait,
not.
sorry, can I clarify one thing? Because this is actually something you and I have talked about offline.
Yep,
and
sure.
And you can add some depth to my understanding of it, which is, I guess there's a distinction between an asset being a security and an asset being part of a securities transaction.
Yep.
Meaning a security is always going to be part of a securities transaction when it's transacted. But I suppose an asset could be part of a securities transaction without being a security. And so part of what I'm wondering here when I'm asking about layer 2s is like, if let's just say token A is not a security according to this, and I traded on layer 1, versus I traded on layer 2, that shouldn't make a distinction. That shouldn't differentiate whether token A is a security or not, right?
Yes, but that's not right. So the definition, having pulled it out here, so a digital commodity means a digital asset, right? So there's a digital asset as a wider subset, could include an NFT, includes wider set of things. It means a digital asset that is intrinsically linked to a blockchain system. So among the questions that came up, like, is a meme coin intrinsically linked? Well, maybe it is, maybe it's not, the value of which is derived from, or reasonably expected to be derived from, the use in a blockchain system. Again, you hear all these, right? So, and then for purposes of, it keeps going. For purposes of this subparagraph, a digital asset is intrinsically linked to a blockchain system if the digital asset is directly related to the functionality or operation of the blockchain system, or the activities or services for which the blockchain system is created or utilized, including where the digital asset is 1, issued or generated by the form of programmatic functioning, used to transfer value, used to access the activities. It's got a long, complicated definition. And look, they're doing a great job. I'm not criticizing the effort. I'm saying that inevitably, once you go down that prescriptive route, you have to answer each and every one of these questions. Right. And so we ultimately have a very policy-oriented question before us. We could try and make the most prescriptive, clear, and precise set of definitions and risk nobody knows what it is or how to deal with it or what have you. Or you could have a more principles-based thing and recognize that you're going to have to people screw around and people will create edge cases unequivocally. That's what crypto people do. So it's really a policy question of which thing, which one do you value more? Very prescriptive, but absurdly complex, or much more clear and simple, but having to deal with edge cases.
Right. So I think you're alluding very strongly towards the Senate version, and we want to ask you about that too in a moment. Sure. But I just want to clarify one last thing on the layer 2 point. It sounds like the relevance of whether a layer 2 is a blockchain or not for the legislation that we were just talking about is primarily coming from identifying the native asset on the layer 2 as a security or not, or rather I should say as a digital commodity or not,
Right.
right? And so Bitcoin is the native asset on a layer 1. And so at a high level, this is how it's going to end up as a digital commodity. Whereas if I look at a layer 2 unit of account, that's not, I don't know whether that's going to preclude it from being a digital commodity, but that's essentially the reason why we're drawing a distinction between layer 2s being blockchains or not. We're really thinking about the asset which is native to it and whether that should become a digital commodity as a consequence.
Or no, but the defined term blockchain runs through the whole bill. And so if you don't know whether something is or is not a blockchain, then you have many different questions, not just that question. So there are a lot of questions. But that's inherent in having very, very precise technical definitions. It's like you gotta pick your poison there.
Okay, but then let me ask one last question if I can here. So the reason why I'm sort of fixating on this is I'm trying to understand whether the regulator for my transaction is going to be different when I trade on layer 2 or layer 1 if it's essentially the same asset, right? So Ether versus wrapped Ether, Ether on layer 1 and wrapped Ether on layer 2. Does this bill draw a line between those interactions? Because I suppose technically by drawing a distinction between saying layer 2s are not blockchains, there is like
first they endeavored to, just let me be clear, they endeavored to address this by adding some broader language that would seek to expand the definition of blockchain, which is wonderful. But then how much does it expand it? Then what is that? Right. So the point is that Clarity Act is not law, and it's directionally something. The Clarity Act contemplates that the SEC will craft regulations that further provide detail on how all of this works. When do we get those regulations? And will they make it more easy to understand or less easy to understand, right? Again, many well-intentioned people will look at it, but it's one of those processes. They say, like, watching laws made in sausages, you don't want to know how it works. And the same goes for regulation. So, your questions are all important ones, Fahad. The challenge is we don't really know right now. We may have to wait for regulations. And then when we get the regulations, we may still not know, because these are edge cases along the way.
You see.
One clarifying question before you switch, Fahad, is that you keep on saying blockchains, but there's no mention of, is it a public blockchain or a private blockchain?
Yeah, there's the references. It's 260 pages. You got every possible thing you could want in there. Yes, public and permissionless. And there's also an idea, they moved away in Clarity from the idea of decentralization, which I think was a wise choice. And instead, they did what good people do, is they made up their own term and then defined that. And they made up their own term, maturity, and then they define maturity. So you don't have to deal with all the baggage associated with decentralization. I know we're going to want to talk a little bit about that. So again, kind of smart in that it allows you to sidestep difficult questions on what is or is not decentralized. But on the other hand, it means that you've got this whole other new concept, which is kind of made up out of whole cloth, which is maturity. And is a blockchain or blockchain system mature or not? And then you have to reconcile with that. That's not necessarily the way the world works or the way project teams work.
Got it. So, that nugget there about maturity is very interesting, and I'm tempted to ask you about it, but then I won't have time to ask you about the Senate version. So I guess we're gonna have to pick, and I'm gonna ask you, could you tell us a little bit about the Senate version and also contrast it from the House version? I know you've contrasted a bit already, but if you could give us a little bit more detail on that.
Yeah. So the Senate version really does its best to sort of, in a tweet thread, I said, cut through the Gordian knot of all this complexity and just come up with a very sort of simple kind of framework, which is, if something intangible is sold in a securities transaction, like the kind you pitched to me a little while ago, right? Hey, Lewis, would you like to buy this thing? It's going to go up, cha, cha, cha. If something's sold and it doesn't convey any rights or give you any benefits or interest in a person, well, then how can it be a security? It's not a security, the thing itself. And that's pretty easy to understand. You can examine it. Well, are there any rights or interests conveyed? No, there are not. Not a security. Okay. Now people worry, okay, that's nice, simple, clear, pretty easy. You don't need a lot of technology to figure it out. But like, could somebody create an edge case? And anybody who follows on Twitter knows that There's a particular person who's very focused on this issue, and it's a fair question to ask. I don't begrudge asking the question. Are there things you could say, well, it's not really a legal interest, but it's kind of like that, and so are people going to use that to circumvent the securities laws? And this is a philosophical point. I don't believe so. I believe those kind of edge cases can easily be shut down with regulations or court actions because people understand broadly what we're talking about. And there's just not a market for selling things that have no value or purpose. But here's the deal, Fahad. I've got a company. I'm going to sell you a number and it does nothing. It's value with the nothing, but I don't know. Maybe I'll be nice to you because you bought the number from me. You might give me $10. Are you going to give me $100 million on the idea that maybe I'll be nice to you? That's not really the way companies work. I don't think that, and if they do, they'll be circumventing the law and subject to prosecution. So I think, it's, you just have to pick. You're going to deal with edge cases or you're going to deal with hyper prescriptive rules. You gotta sort of pick which one you want to go with. And we'll see because our elected officials are going to consider both of those approaches.
So if I could just ask you, just to make things a bit more concrete for at least for, non-lawyers like me. So for instance, imagine I had a token that conferred, I wouldn't say the right, but in your language, I would say the ability to, when I interact with a particular smart contract, it conferred the ability for me to get what a layperson might interpret as a lower fee for interacting with the program relative to anybody who doesn't hold this token. So part of what I'm getting at here is, right, like your own work has highlighted kind of the distinction between rights and abilities. I have the ability to send a message to this network and it does stuff, right? It changes numbers on a ledger, right? At the end of the day. And so if the code logic that runs subsequent to me sending a message is a function, for instance, of whether or not I have a holding of the token, which again is also just a ledger entry, does that, for instance, entail any kind of interest? I guess in the sense that you were describing earlier, right? Is this question making sense?
Yeah, it's making complete sense. Again, to the extent it's through the operation of computers that operate on their own and independently of anyone else, those abilities don't give you rights against anybody. We've never in the history of securities laws had a security that did not create a legal relationship with someone. There may have been like an offering, like to say, oh, if you give me money, I'll do this for you. That's a legal relationship. But just simply the ability to give instructions, a hammer function is to hammer nails. If, it finds a nail it can't hammer, that you can't go back and sue the hammer guy, or unless the hammer guy gave you a representation that says, I promise you, Fahad, if you buy this hammer from me, it will hammer any nail you ever see. That's a legal relationship. Now they made a promise to you. This hammer will hammer any nail. But if you just buy a hammer and hope and expect it'll have the ability to drive in nails and you find a nail it won't drive in, you don't have a claim against the hammer. The question is, has someone created a relationship with you that you can understand and say, this represents my relationship with you? You have to understand that. I think where the Gary Gensler SEC went off the rails is they had this idea that there were these inchoate promises in the air that nobody really knew what they were, when they began, and when they ended. And it was very difficult to evaluate. Well, I don't know if somebody's made me a promise. Somebody tweeted something. Is that a promise to me? What does that mean? It doesn't make any sense. I think if we have other issues with promotions of schemes, then we have tools to address those. So if somebody is inducing someone to give them money for investment purposes, we have very clear laws to address that. It's just creating something that does not in and of itself create any legal relationship is so far outside the bounds of what we understand to be securities that I think the Senate wisely said that's not how we think the law should work going forward.
I see. So, you mentioned maturity when you were talking about the House version and they supported, I guess, essentially put forth this concept. And we've also sort of talked around the word decentralization, which, offline you and I have talked about it also playing a role. So could you maybe add a little bit more context to what the meaning of maturity is in the House bill and sort of how decentralization, that term plays into either of these versions?
Sure. So a mature blockchain or blockchain system is one that is not controlled by one person or one group of affiliated persons. And, so I think mature blockchain system is a blockchain system like an app that together with its related digital commodity is not controlled by any person or any group of persons under common control. Wonderful. And then it later goes on to add a sort of 6-part safe harbor stroke test for what does it mean to really be under common control. The issue that I get into for me with this idea of mixing up maturity with or decentralization with security status is that is sort of a ephemeral thing. It's something may be decentralized or mature. It may become mature or unbecome mature. There are all these factors. We can't have that driving whether just some third person, Fahad, own an asset, and you want to know if you can make a market in that asset without having to register in the SEC. You can't do some long journey of discovery to figure out exactly how decentralized it is. It just does not work or make sense. They endeavor in the House to deal with this by focusing the outcome of maturity on whether insiders who have gotten tokens at the early stage can readily sell their tokens. My point of view on this is, and this is strictly a policy point, is what on earth is the government doing telling you how long you should be locked up when you buy a token or receive a token? It's completely out of bounds. The market is the one that says that. And we have very effective market mechanisms. As a general matter, the market will expect lockups of 1 year, 2 years, 3 years, depending on circumstances. But the government should not be prescribing that. That's the most sort of non-free market sort of approach I could possibly think of. It's put out there because, well, but how else do we know if, something's really decentralized and these are the people working on it? But generally, projects are given 4 years to become mature. My concern is, well, what happens after 4 years? So let's say you're not mature after 4 years. What are you going to do? The token's already out there. They're held by a lot of people. You can take them away. You can't do that. You got nothing. We're going to be really mad at you. It doesn't really kind of work. Moreover, 4 years is a heck of a long time for someone. And look, it takes time to sort of become decentralized. I think the bigger issue is nobody is grappling with the most basic test or question, I should say, Fahad, which you and I have talked about. Is the market that supportive of decentralization? Like, it's a wonderful ethos. I support it. You support it. Is the market supporting it? Or is the market looking for what works and frankly, not putting a lot of weight on how decentralized something is? We see a lot of projects that are saying, wow, this is amazing. We could re-centralize that. And nobody's like saying, don't do that. We have layer 2s that are operated by a single sequencer. We won't use any names, that are totally, controlled by one person. Do you have an escape route to an L1? Perhaps. If that particular person decided to have a problem, you'd be in, as we say, to use a technical term, shit shape, right? So, I think we have a larger issue to grapple with, which is we want decentralization. We need decentralization, but the market, to date at least, is just not strongly supporting that. And that kind of covers over all of these questions. I'm not taking a view. I'm not saying who cares about decentralization. Rest assured, I'll get some nasty tweets. Nobody cares about decentralization. I'm only just expressing a view that we see many in the market behaving in ways that are not consistent with strong support for decentralization.
Lewis, I'm very confused. Like, I follow everything you said, but I'm very confused about how maturity is being somehow tied to decentralization. Because when I hear maturity and, you mentioned things like 4 years, okay, I think about how long a project has been in existence. But then when you tie it back to decentralization, you pointed out like something can switch from mature to immature if it sort of collapses in its decentralization and becomes centralized again.
After 2 beers, that's me,
Yeah. But yeah, I don't know if this is is it like designed to be written this way, where maturity is actually somehow talking about like, is it being used synonymously with decentralization? Should it really be decentralization, or is it assumed
it's a
that
proxy for decentralization? Sorry, looking for it. So it's a proxy. So there's a process for certification that something is decentralized, and then there's a rebuttable presumption, and then certification and then a series of tests that are provided. And there could be stays of decentralization and all of these different, complex sort of arrangements. And then there's criteria. And the criteria provide, gosh, you got to just keep going here. You're deemed mature. I just keep going here when you've got, I think it's 6 factors, if I recall. The market value of the digital commodity has a value that's substantially derived from the functioning of a blockchain system. The digital commodity issuer has made public a development plan describing, et cetera, et cetera. The system is functional. I mean, one of the issues I have with decentralization is, I think, everybody understands software is never finished. So the idea that you're done here is really not right. Everything is evolving always. And the question is, who's going to be doing that evolving, right? Who has the most at stake? It's wonderful if there was just this community of beautiful people who are all going to say kumbaya and write code to keep updating something. But it doesn't work that way. We need people who are incentivized, who hold the tokens, who are coordinated through somebody, a foundation, a labs company, whatever it may be, and all of that. So ultimately, it's very hard to resist that entropic pull that, you're just, well, if we just let it be. Some scholars from the University of Chicago wrote a famous paper in which they posited something they called the Bahamas test, which is, well, it's decentralized when the people who did it can go off to the Bahamas and relax on the beach and the thing will just run itself. And we all know in reality, after many, many years, that's not how blockchain systems work. They constantly need to be updated. And sometimes it's for technology reasons and sometimes it's for competitive reasons. Wow. I run a decentralized exchange, but somebody else just came up with a new feature. Holy cow, got to deal with that. Otherwise, I'm going to lose market share. Wonderful. Understood. That's appropriate. Well, who's going to figure that out? And, et cetera, et cetera, et cetera. So there are criteria for something being mature in the Clarity Act. And again, I want to emphasize what great work the House did on this. It's not a criticism of what they did. It's just an inherent, once you go down that path, you are stuck with having to sort of figure out all these very, very precise questions, which are really difficult to answer. So it's not a criticism. It's just like, which way are we going to go and which way best serves the general populace of the U.S. and the crypto community of the U.S. We want something that's fair, understandable, operationally usable, and maybe Clarity can be made to work. I'm not here to say it won't. But I am here to say we have to recognize where the trade-offs are on both sides.
Got it. There's so much more we can talk about, even in that last couple of minutes of what you said. But I know we have to be respectful of your time. So I'm sure we'll have you back on this podcast again. But yeah, thank you so much for all the insights that you've dropped on us today. Me, as someone who doesn't follow the news that much and also doesn't know the law, I feel like I have such a better understanding of what's been going on, especially in the Clarity Act.
Yeah, thank you so much, Lewis.
It's a pleasure, gentlemen. Thank you for including me. Thank you to the kind listeners who made it all the way through to the end.
Yeah.
Take good care.
Okay. Thanks. And be sure to follow Lewis at New York or NY Crypto Lawyer on X. And then you can follow me and Fahad at Crypto Econ Prof and me at Brad Bachu. Okay. Thank you.
Thanks again, Lewis.